The Revised Penal Code of the Republic of the Philippines, Volume 3.
Foreword to the video book volumes. Note: this foreword is not part of the Revised Penal Code itself. To skip this section, go to the table of contents in the video description below, and click on the time link of your desired section. This section is intended to quickly explain how the Revised Penal Code is organized and presented insofar as this and 3 other related video book volumes are concerned. This section also explains how best to navigate through, and find specific sections, in this 4-volume video book series. The Revised Penal Code's hierarchical order. The Revised Penal Code document is organized in the following hierarchical order. Number 1. Books. The Revised Penal Code is divided into 2 books, namely: Book 1. General provisions regarding the date of enforcement and application of the provisions of this code, and regarding the offenses, the persons liable and the penalties. Book 2. Crimes and penalties. Number 2. Titles. Each of the 2 books is divided into several titles. Book 1 has 5 titles, while Book 2 has 15 titles. The title numbers start at number 1 for each book. Number 3. Chapters. Titles are subdivided into chapters. Chapter numbers restart at number 1 for each new title. Number 4. Sections. When a chapter is considerably long, it may be further subdivided into sections. Section numbers restart at number 1 for each new chapter. Number 5. Articles. An article is the Revised Penal Code's basic unit of information. Each article is essentially a unique provision of the Revised Penal Code. The Revised Penal Code has a total of 367 articles numbered continuously from 1 through 367. Article numbers do not restart at number 1 for each book, title, chapter, or section. Instead, the article numbers continue through, from Book 1 to Book 2, and through all the titles, chapters, and sections. Number 6. Numbered and/or lettered subsections. Some articles may have numbered and/or lettered subsections. This is particularly true for articles that need to list down and enumerate certain items, like conditions, requirements, etc. There can also be nested lists inside articles, in which case they are presented as lettered lists within numbered lists, or vice versa. The 4 video book volumes. The Revised Penal Code is presented herewith as a 4-volume video book series, as follows. Volume 1 contains an introduction, which is not part of the Revised Penal Code itself, and Book 1 of the Revised Penal Code. Volumes 2 to 4 contain Book 2 of the Revised Penal Code, with each volume containing part of Book 2. The 15 titles of Book 2 are divided into Part 1, Part 2, and Part 3, with each part containing 5 titles each. Take note that Book 1 and Book 2 are actual labels used in the Revised Penal Code. Either way, each volume is preceded by this foreword, with a table of contents to preview the contents of the volume. Each of the 4 volumes can be accessed and consumed as a video presentation, or as part of the Revised Penal Code playlist in our YouTube channel. Table of Contents, Volume 3. The Revised Penal Code. Book 2, Crimes and Penalties, pages 6 to 94. Title 6, Crimes Against Public Morals, pages 7 to 12. Title 7, Crimes Committed by Public Officers, pages 13 to 32. Title 8, Crimes Against Persons, pages 33 to 45. Title 9, Crimes Against Personal Liberty and Security, pages 46 to 61. Title 10, Crimes Against Property, pages 62 to 94. This table of content is also available in the video description below, with clickable time links to quickly go to each specified portion of the Revised Penal Code. The Revised Penal Code, Volume 3, will commence in the next page. Continuing from Volume 2, Volume 3 will start with Book 2, Title 6, and Article 195.
Book 2. Crimes and Penalties. Title 6. Crimes Against Public Morals. Chapter 1. Gambling and Betting. Article 195. What acts are punishable in gambling? A. The penalty of arresto mayor or a fine not exceeding 200 pesos, and, in case of recidivism, the penalty of arresto mayor or a fine ranging from 200 or 6,000 pesos, shall be imposed upon 1. Any person other than those referred to in subsections B and C, who, in any manner shall directly or indirectly take part in any game of Monte, Hui Tang or any other form of lottery, policy, banking, or percentage game, dog races, or any other game of scheme the result of which depends wholly or chiefly upon chance or hazard, or wherein wagers consisting of money, articles of value or representative of value are made, or in the exploitation or use of any other mechanical invention or contrivance to determine by chance the loser or winner of money or any object or representative of value. 2. Any person who shall knowingly permit any form of gambling referred to in the preceding subdivision to be carried on in any uninhabited or uninhabited place of any building, vessel or other means of transportation owned or controlled by him. If the place where gambling is carried on has the reputation of a gambling place or that prohibited gambling is frequently carried on therein, the culprit shall be punished by the penalty provided for in this article in its maximum period. B. The penalty of prisión correccional in its maximum degree shall be imposed upon the maintainer, conductor, or banker in a game of juting or any similar game. C. The penalty of prisión correccional in its medium degree shall be imposed upon any person who shall, knowingly and without lawful purpose, have in his possession and lottery list, paper or other matter containing letters, figures, signs or symbols which pertain to or are in any manner used in the game of Hui Tang or any similar game which has taken place or about to take place. Article 196. Importation, sale and possession of lottery tickets or advertisements. The penalty of arresto mayor in its maximum period to prisión correccional in its minimum period or a fine ranging from 200 to 2,000 pesos, or both, in the discretion of the court, shall be imposed upon any person who shall import into the Philippine Islands from any foreign place or port any lottery ticket or advertisement or, in connivance with the importer, shall sell or distribute the same. Any person who shall knowingly and with intent to use them, have in his possession lottery tickets or advertisements, or shall sell or distribute the same without connivance with the importer of the same, shall be punished by arresto menor, or a fine not exceeding 200 pesos, or both, in the discretion of the court. The possession of any lottery ticket or advertisement shall be prima facie evidence of an intent to sell, distribute or use the same in the Philippine Islands. Article 198. Illegal betting on horse race. The penalty of arresto menor or a fine not exceeding 200 pesos, or both, shall be imposed upon any person who except during the period allowed by law, shall be on horse races. The penalty of arresto mayor or a fine ranging from 200 to 2,000 pesos, or both, shall be imposed upon any person who, under the same circumstances, shall maintain or employ a totalizer or other device or scheme for betting on horse races or realizing any profit therefrom. For the purposes of this article, any race held in the same day at the same place shall be held punishable as a separate offense, and if the same be committed by any partnership, corporation, or association, the president and the directors or managers thereof shall be deemed to be principals in the offense if they have consented to or knowingly tolerated its commission. Article 199. Illegal cockfighting. The penalty of arresto menor or a fine not exceeding 200 pesos, or both, in the discretion of the court, shall be imposed upon 1. Any person who directly or indirectly participates in cockfights, by betting money or other valuable things, or who organizes cockfights at which bets are made, on a day other than those permitted by law. 2. Any person who directly or indirectly participates in cockfights, at a place other than a licensed cockpit. Chapter 2. Offenses against Decency and Good Customs. Article 200. Grave Scandal. The penalties of arresto mayor and public censure shall be imposed upon any person who shall offend against decency or good customs by any highly scandalous conduct not expressly falling within any other article of this code. Article 201. Immoral doctrines, obscene publications and exhibitions and indecent shows. The penalty of prisión mayor or a fine ranging from 6,000 to 12,000 pesos, or both such imprisonment and fine, shall be imposed upon 1. Those who shall publicly expound or proclaim doctrines openly contrary to public morals. 2. A. The authors of obscene literature, publish with their knowledge in any form the editors publishing such literature and the owners/operators of the establishment selling the same. B. Those who, in theaters, fairs, cinematographs, or any other place, exhibit, indecent or immoral plays, scenes, acts or shows, whether live or in film, which are prescribed by virtue hereof, shall include those which, 1. Glorify criminals or condone crimes, 2. Serve no other purpose but to satisfy the market for violence, lust or pornography, 3. Offend any race or religion, 4. Tend to abet traffic in and use of prohibited drugs, and 5. Are contrary to law, public order, morals, and good customs, established policies, lawful orders, decrees and edicts. 3. Those who shall sell, give away or exhibit films, prints, engravings, sculpture or literature which are offensive to morals. As amended by PD numbers 960 and 969. Article 202. Vagrants and prostitutes, penalty. The following are vagrants. 1. Any person having no apparent means of subsistence, who has the physical ability to work and who neglects to apply himself or herself to some lawful calling. 2. Any person found loitering about public or semi-public buildings or places or trampling or wandering about the country or the streets without visible means of support. 3. Any idle or dissolute person who lodges in houses of ill-famed ruffians or pimps and those who habitually associate with prostitutes. 4. Any person who, not being included in the provisions of other articles of this code, shall be found loitering in any inhabited or uninhabited place belonging to another without any lawful or justifiable purpose. 5. Prostitutes. For the purposes of this article, women who, for money or profit, habitually indulge in sexual intercourse or lascivious conduct, are deemed to be prostitutes. Any person found guilty of any of the offenses covered by this article shall be punished by arresto menor or a fine not exceeding 200 pesos, and in case of recidivism, by arresto mayor in its medium period to prisión correccional in its minimum period or a fine ranging from 200 to 2,000 pesos, or both, in the discretion of the court. Title 7. Crimes committed by public officers. Chapter 1. Preliminary Provisions. Article 203. Who are public officers? For the purpose of applying the provisions of this and the preceding titles of this book, any person who, by direct provision of the law, popular election or appointment by competent authority, shall take part in the performance of public functions in the government of the Philippine Islands, shall perform in said government or in any of its branches public duties as an employee, agent or subordinate official, of any rank or class, shall be deemed to be a public officer. Chapter 2. Malfeasance and Misfeasance in Office. Section 1. Dereliction of Duty. Article 204. Knowingly rendering unjust judgment. Any judge who shall knowingly render an unjust judgment in any case submitted to him for decision, shall be punished by prisión mayor and perpetual absolute disqualification. Article 205. Judgment rendered through negligence. Any judge who, by reason of inexcusable negligence or ignorance shall render a manifestly unjust judgment in any case submitted to him for decision shall be punished by arresto mayor and temporary special disqualification. Article 206. Unjust interlocutory order. Any judge who shall knowingly render an unjust interlocutory order or decree shall suffer the penalty of arresto mayor in its minimum period and suspension, but if he shall have acted by reason of inexcusable negligence or ignorance and the interlocutory order or decree be manifestly unjust, the penalty shall be suspension. Article 207. Malicious delay in the administration of justice. The penalty of prisión correccional in its minimum period shall be imposed upon any judge guilty of malicious delay in the administration of justice. Article 208. Prosecution of offenses and negligence and tolerance. The penalty of prisión correccional in its minimum period and suspension shall be imposed upon any public officer or officer of the law who, in dereliction of the duties of his office, shall maliciously refrain from instituting prosecution for the punishment of violators of the law, or shall tolerate the commission of offenses. Article 209. Betrayal of trust by an attorney or solicitor. Revelation of secrets. In addition to the proper administrative action, the penalty of prisión correccional in its minimum period, or a fine ranging from 200 to 1,000 pesos, or both, shall be imposed upon any attorney at law or solicitor, procurador judicial, who, by any malicious breach of professional duty or of inexcusable negligence or ignorance, shall prejudice his client, or reveal any of the secrets of the latter learned by him in his professional capacity. The same penalty shall be imposed upon an attorney at law or solicitor, procurador judicial, who, having undertaken the defense of a client or having received confidential information from said client in a case, shall undertake the defense of the opposing party in the same case, without the consent of his first client. Section 2. Bribery. Article 210. Direct bribery. Any public officer who shall agree to perform an act constituting a crime, in connection with the performance of this official duties, in consideration of any offer, promise, gift or present received by such officer, personally or through the mediation of another, shall suffer the penalty of prisión mayor in its medium and maximum periods and a fine of not less than the value of the gift and not less than 3 times the value of the gift in addition to the penalty corresponding to the crime agreed upon, if the same shall have been committed. If the gift was accepted by the officer in consideration of the execution of an act which does not constitute a crime, and the officer executed said act, he shall suffer the same penalty provided in the preceding paragraph, and if said act shall not have been accomplished, the officer shall suffer the penalties of prisión correccional, in its medium period and a fine of not less than twice the value of such gift. If the object for which the gift was received or promised was to make the public officer refrain from doing something which it was his official duty to do, he shall suffer the penalties of prisión correccional in its maximum period and a fine of not less than the value of the gift and not less than 3 times the value of such gift. In addition to the penalties provided in the preceding paragraphs, the culprit shall suffer the penalty of special temporary disqualification. The provisions contained in the preceding paragraphs shall be made applicable to assessors, arbitrators, appraisal and claim commissioners, experts or any other persons performing public duties. As amended by BP 871, approved May 29, 1985. Article 211. Indirect bribery. The penalties of prisión correccional in its medium and maximum periods, and public censure shall be imposed upon any public officer who shall accept gifts offered to him by reason of his office. As amended by BP 871, approved May 29, 1985. Article 211A. Qualified bribery. If any public officer is entrusted with law enforcement and he refrains from arresting or prosecuting an offender who has committed a crime punishable by reclusion perpetua and/or death in consideration of any offer, promise, gift or present, he shall suffer the penalty for the offense which was not prosecuted. If it is the public officer who asks or demands such gift or present, he shall suffer the penalty of death. As added by Section 4, Republic Act No. 7659. Article 212. Corruption of public officials. The same penalties imposed upon the officer corrupted, except those of disqualification and suspension, shall be imposed upon any person who shall have made the offers or promises or given the gifts or presents as described in the preceding articles. Chapter 3. Frauds and illegal exactions and transactions. Article 213. Frauds against the public treasury and similar offenses. The penalty of prisión correccional in its medium period to prisión mayor in its minimum period, or a fine ranging from 200 to 10,000 pesos, or both, shall be imposed upon any public officer who 1. In his official capacity, in dealing with any person with regard to furnishing supplies, the making of contracts, or the adjustment or settlement of accounts relating to public property or funds, shall enter into an agreement with any interested party or speculator or make use of any other scheme to defraud the government. 2. Being entrusted with the collection of taxes, licenses, fees and other imposts, shall be guilty or any of the following acts or omissions. A. Demanding, directly or indirectly, the payment of sums different from or larger than those authorized by law. B. Failing voluntarily to issue a receipt, as provided by law, for any sum of money collected by him officially. C. Collecting or receiving, directly or indirectly, by way of payment or otherwise things or objects of a nature different from that provided by law. When the culprit is an officer or employee of the Bureau of Internal Revenue or the Bureau of Customs, the provisions of the Administrative Code shall be applied. Article 214. Other frauds. In addition to the penalties prescribed in the provisions of Chapter 6, Title 10, Book 2 of this code, the penalty of temporary special disqualification in its maximum period to perpetual special disqualification shall be imposed upon any public officer who, taking advantage of his official position, shall commit any of the frauds or deceits enumerated in said provisions. Article 215. Prohibited transactions. The penalty of prisión correccional in its maximum period or a fine ranging from 200 to 1,000 pesos, or both, shall be imposed upon any appointed public officer who, during his incumbency, shall directly or indirectly become interested in any transaction of exchange or speculation within the territory subject to his jurisdiction. Article 216. Possession of prohibited interest by a public officer. The penalty of arresto mayor in its medium period to prisión correccional in its minimum period, or a fine ranging from 200 to 1,000 pesos, or both, shall be imposed upon a public officer who directly or indirectly shall become interested in any contract or business in which it is his official duty to intervene. This provisions is applicable to experts, arbitrators and private accountants who, in like manner, shall take part in any contract or transaction connected with the estate or property in appraisal, distribution or adjudication of which they shall have acted, and to the guardians and executors with respect to the property belonging to their wards or estate. Chapter 4. Malversation of public funds or property. Article 217. Malversation of public funds or property and presumption of malversation. Any public officer who, by reason of the duties of his office, is accountable for public funds or property, shall appropriate the same or shall take or misappropriate or shall consent, through abandonment or negligence, shall permit any other person to take such public funds or property, wholly or partially, or shall otherwise be guilty of the misappropriation or malversation of such funds or property, shall suffer 1. The penalty of prisión correccional in its medium and maximum periods, if the amount involved in the misappropriation or malversation does not exceed 200 pesos. 2. The penalty of prisión mayor in its minimum and medium periods, if the amount involved is more than 200 pesos but does not exceed 6,000 pesos. 3. The penalty of prisión mayor in its maximum period to reclusion temporal in its minimum period, if the amount involved is more than 6,000 pesos but is less than 12,000 pesos. 4. The penalty of reclusion temporal, in its medium and maximum periods, if the amount involved is more than 12,000 pesos but is less than 22,000 pesos. If the amount exceeds the latter, the penalty shall be reclusion temporal in its maximum period to reclusion perpetua. In all cases, persons guilty of malversation shall also suffer the penalty of perpetual special disqualification and a fine equal to the amount of the funds malversed or equal to the total value of the property embezzled. The failure of a public officer to have duly forthcoming any public funds or property with which he is chargeable, upon demand by any duly authorized officer, shall be prima facie evidence that he has put such missing funds or property to personal use. As amended by R. 1060. Article 218. Failure of accountable officer to render accounts. Any public officer, whether in the service or separated therefrom by resignation or any other cause, who is required by law or regulation to render account to the insular auditor, or to a provincial auditor and who fails to do so for a period of 2 months after such accounts should be rendered, shall be punished by prisión correccional in its minimum period, or by a fine ranging from 200 to 6,000 pesos, or both. Article 219. Failure of a responsible public officer to render accounts before leaving the country. Any public officer who unlawfully leaves or attempts to leave the Philippine Islands without securing a certificate from the insular auditor showing that his accounts have been finally settled, shall be punished by arresto mayor, or a fine ranging from 200 to 1,000 pesos or both. Article 220. Illegal use of public funds or property. Any public officer who shall apply any public fund or property under his administration to any public use other than for which such fund or property were appropriated by law or ordinance shall suffer the penalty of prisión correccional in its minimum period or a fine ranging from 1/2 to the total of the sum misapplied, if by reason of such misapplication, any damages or embarrassment shall have resulted to the public service. In either case, the offender shall also suffer the penalty of temporary special disqualification. If no damage or embarrassment to the public service has resulted, the penalty shall be a fine from 5 to 50% of the sum misapplied. Article 221. Failure to make delivery of public funds or property. Any public officer under obligation to make payment from government funds in his possession, who shall fail to make such payment, shall be punished by arresto mayor and a fine from 5 to 25% of the sum which he failed to pay. This provision shall apply to any public officer who, being ordered by competent authority to deliver any property in his custody or under his administration, shall refuse to make such delivery. The fine shall be graduated in such case by the value of the thing, provided that it shall not less than 50 pesos. Article 222. Officers included in the preceding provisions. The provisions of this chapter shall apply to private individuals who in any capacity whatever, have charge of any insular, provincial or municipal funds, revenues, or property and to any administrator or depository of funds or property attached, seized or deposited by public authority, even if such property belongs to a private individual. Chapter 5. Infidelity of public officers. Section 1. Infidelity in the custody of prisoners. Article 223. Conniving with or consenting to evasion. Any public officer who shall consent to the escape of a prisoner in his custody or charge shall be punished. 1. By prisión correccional in its medium and maximum periods and temporary special disqualification in its maximum period to perpetual special disqualification, if the fugitive shall have been sentenced by final judgment to any penalty. 2. By prisión correccional in its minimum period and temporary special disqualification, in case the fugitive shall not have been finally convicted but only held as a detention prisoner for any crime or violation of law or municipal ordinance. Article 224. Evasion through negligence. If the evasion of the prisoner shall have taken place through the negligence of the officer charged with the conveyance or custody of the escaping prisoner, said officer shall suffer the penalties of arresto mayor in its maximum period to prisión correccional in its minimum period and temporary special disqualification. Article 225. Escape of prisoner under the custody of a person not a public officer. Any private person to whom the conveyance or custody or a prisoner or person under arrest shall have been confided, who shall commit any of the offenses mentioned in the two preceding articles, shall suffer the penalty next lower in degree than that prescribed for the public officer. Section 2. Infidelity in the custody of document. Article 226. Removal, concealment or destruction of documents. Any public officer who shall remove, destroy or conceal documents or papers officially entrusted to him shall suffer 1. The penalty of prisión mayor and a fine not exceeding 1,000 pesos, whenever serious damage shall have been caused thereby to a third party or to the public interest. 2. The penalty of prisión correccional in its minimum and medium period and a fine not exceeding 1,000 pesos, whenever the damage to a third party or to the public interest shall not have been serious. In either case, the additional penalty of temporary special disqualification in its maximum period to perpetual disqualification shall be imposed. Article 227. Officer breaking seal. Any public officer charged with the custody of papers or property sealed by proper authority, who shall break the seals or permit them to be broken, shall suffer the penalties of prisión correccional in its minimum and medium periods, temporary special disqualification and a fine not exceeding 2,000 pesos. Article 228. Opening of closed documents. Any public officer not included in the provisions of the next preceding article who, without proper authority, shall open or shall permit to be opened any closed papers, documents or objects entrusted to his custody, shall suffer the penalties or arresto mayor, temporary special disqualification and a fine of not exceeding 2,000 pesos. Section 3. Revelation of secrets. Article 229. Revelation of secrets by an officer. Any public officer who shall reveal any secret known to him by reason of his official capacity, or shall wrongfully deliver papers or copies of papers of which he may have charge and which should not be published, shall suffer the penalties of prisión correccional in its medium and maximum periods, perpetual special disqualification and a fine not exceeding 2,000 pesos if the revelation of such secrets or the delivery of such papers shall have caused serious damage to the public interest. Otherwise, the penalties of prisión correccional in its minimum period, temporary special disqualification and a fine not exceeding 50 pesos shall be imposed. Chapter 6. Other offenses or irregularities by public officers. Article 231. Open disobedience. Any judicial or executive officer who shall openly refuse to execute the judgment, decision or order of any superior authority made within the scope of the jurisdiction of the latter and issued with all the legal formalities, shall suffer the penalties of arresto mayor in its medium period to prisión correccional in its minimum period, temporary special disqualification in its maximum period and a fine not exceeding 1,000 pesos. Article 232. Disobedience to order of superior officers, when said order was suspended by inferior officer. Any public officer who, having for any reason suspended the execution of the orders of his superiors, shall disobey such superiors after the latter have disapproved the suspension, shall suffer the penalties of prisión correccional in its minimum and medium periods and perpetual special disqualification. Article 233. Refusal of assistance. The penalties of arresto mayor in its medium period to prisión correccional in its minimum period, perpetual special disqualification and a fine not exceeding 1,000 pesos, shall be imposed upon a public officer who, upon demand from competent authority, shall fail to lend his cooperation towards the administration of justice or other public service, if such failure shall result in serious damage to the public interest, or to a third party. Otherwise, arresto mayor in its medium and maximum periods and a fine not exceeding 500 pesos shall be imposed. Article 234. Refusal to discharge elective office. The penalty of arresto mayor or a fine not exceeding 1,000 pesos, or both, shall be imposed upon any person who, having been elected by popular election to a public office, shall refuse without legal motive to be sworn in or to discharge the duties of said office. Article 235. Maltreatment of prisoners. The penalty of arresto mayor in its medium period to prisión correccional in its minimum period, in addition to his liability for the physical injuries or damage caused, shall be imposed upon any public officer or employee who shall overdo himself in the correction or handling of a prisoner or detention prisoner under his charge, by the imposition of punishment not authorized by the regulations, or by inflicting such punishment in a cruel and humiliating manner. If the purpose of the maltreatment is to extort a confession, or to obtain some information from the prisoner, the offender shall be punished by prisión correccional in its minimum period, temporary special disqualification and a fine not exceeding 500 pesos, in addition to his liability for the physical injuries or damage caused. Section 2. Anticipation, prolongation and abandonment of the duties and powers of public office. Article 236. Anticipation of duties of a public office. Any person who shall assume the performance of the duties and powers of any public officer or employment without first being sworn in or having given the bond required by law, shall be suspended from such office or employment until he shall have complied with the respective formalities and shall be fined from 200 to 500 pesos. Article 237. Prolonging performance of duties and powers. Any public officer shall continue to exercise the duties and powers of his office, employment or commission, beyond the period provided by law, regulation or special provisions applicable to the case, shall suffer the penalties of prisión correccional in its minimum period, special temporary disqualification in its minimum period and a fine not exceeding 500 pesos. Article 238. Abandonment of office or position. Any public officer who, before the acceptance of his resignation, shall abandon his office to the detriment of the public service shall suffer the penalty of arresto mayor. if such office shall have been abandoned in order to evade the discharge of the duties of preventing, prosecuting or punishing any of the crime falling within Title I and Chapter 1 of Title III of Book 2 of this Code, the offender shall be punished by prisión correccional in its minimum and medium periods, and by arresto mayor if the purpose of such abandonment is to evade the duty of preventing, prosecuting or punishing any other crime. Section 3. Usurpation of powers and unlawful appointments. Article 239. Usurpation of legislative powers. The penalties of prisión correccional in its minimum period, temporary special disqualification and a fine not exceeding 1,000 pesos, shall be imposed upon any public officer who shall encroach upon the powers of the legislative branch of the government, either by making general rules or regulations beyond the scope of his authority, or by attempting to repeal a law or suspending the execution thereof. Article 240. Usurpation of executive functions. Any judge who shall assume any power pertaining to the executive authorities, or shall obstruct the latter in the lawful exercise of their powers, shall suffer the penalty of arresto mayor in its medium period to prisión correccional in its minimum period. Article 241. Usurpation of judicial functions. The penalty of arresto mayor in its medium period to prisión correccional in its minimum period and shall be imposed upon any officer of the executive branch of the government who shall assume judicial powers or shall obstruct the execution of any order or decision rendered by any judge, within its jurisdiction. Article 242. Disobeying request for disqualification. Any public officer who, before the question of jurisdiction is decided, shall continue any proceeding after having been lawfully required to refrain from so doing, shall be punished by arresto mayor and a fine not exceeding 500 pesos. Article 243. Orders or requests by executive officers to any judicial authority. Any executive officer who shall address any order or suggestion to any judicial authority with respect to any case or business coming within the exclusive jurisdiction of the courts of justice shall suffer the penalty of arresto mayor and a fine not exceeding 500 pesos. Article 244. Unlawful appointments. Any public officer who shall knowingly nominate or appoint to any public office any person lacking the legal qualifications therefor, shall suffer the penalty of arresto mayor and a fine not exceeding 1,000 pesos. Section 4. Abuses against chastity. Article 245. Abuses against chastity and penalties. The penalties of prisión correccional in its medium and maximum periods and temporary special disqualification shall be imposed. 1. Upon any public officer who shall solicit or make immoral or indecent advances to a woman interested in matters pending before such officer for decision, or with respect to which he is required to submit a report to or consult with a superior officer. 2. Any warden or other public officer directly charged with the care and custody of prisoners or persons under arrest who shall solicit or make immoral or indecent advances to a woman under his custody. If the person solicited be the wife, daughter, sister of relative within the same degree by affinity of any person in the custody of such warden or officer, the penalties shall be prisión correccional in its minimum and medium periods and temporary special disqualification. Title 8. Crimes against persons. Chapter 1. Destruction of life. Section 1. Parricide, murder, homicide. Article 246. Parricide. Any person who shall kill his father, mother, or child, whether legitimate or illegitimate, or any of his ascendants or descendants, or his spouse, shall be guilty of parricide and shall be punished by the penalty of reclusion perpetua to death. Article 247. Death or physical injuries inflicted under exceptional circumstances. Any legally married person who, having surprised his spouse in the act of committing sexual intercourse with another person, shall kill any of them or both of them in the act or immediately thereafter, or shall inflict upon them any serious physical injury, shall suffer the penalty of destierro. If he shall inflict upon them physical injuries of any other kind, he shall be exempt from punishment. These rules shall be applicable, under the same circumstances, to parents with respect to their daughters under 18 years of age, and their seducer, while the daughters are living with their parents. Any person who shall promote or facilitate the prostitution of his wife or daughter, or shall otherwise have consented to the infidelity of the other spouse shall not be entitled to the benefits of this article. Article 248. Murder. Any person who, not falling within the provisions of Article 246 shall kill another, shall be guilty of murder and shall be punished by reclusion temporal in its maximum period to death, if committed with any of the following attendant circumstances. 1. With treachery, taking advantage of superior strength, with the aid of armed men, or employing means to weaken the defense or of means or persons to ensure or afford impunity. 2. In consideration of a price, reward, or promise. 3. By means of inundation, fire, poison, explosion, shipwreck, stranding of a vessel, derailment or assault upon a streetcar or locomotive, fall of an airship, by means of motor vehicles, or with the use of any other means involving great waste and ruin. 4. On occasion of any of the calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic or other public calamity. 5. With evident premeditation. 6. With cruelty, by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. Article 249. Homicide. Any person who, not falling within the provisions of Article 246, shall kill another without the attendance of any of the circumstances enumerated in the next preceding article, shall be deemed guilty of homicide and be punished by reclusion temporal. Article 250. Penalty for frustrated parricide, murder or homicide. The courts, in view of the facts of the case, may impose upon the person guilty of the frustrated crime of parricide, murder or homicide, defined and penalized in the preceding articles, a penalty lower by 1 degree than that which should be imposed under the provision of Article 50. The courts, considering the facts of the case, may likewise reduce by 1 degree the penalty which under Article 51 should be imposed for an attempt to commit any of such crimes. Article 251. Death caused in a tumultuous affray. When, while several persons, not composing groups organized for the common purpose of assaulting and attacking each other reciprocally, quarrel and assault each other in a confused and tumultuous manner, and in the course of the affray someone is killed, and it cannot be ascertained who actually killed the deceased, but the person or persons who inflicted serious physical injuries can be identified, such person or persons shall be punished by prisión mayor. If it cannot be determined who inflicted the serious physical injuries on the deceased, the penalty of prisión correccional in its medium and maximum periods shall be imposed upon all those who shall have used violence upon the person of the victim. Article 252. Physical injuries inflicted in a tumultuous affray. When in a tumultuous affray as referred to in the preceding article, only serious physical injuries are inflicted upon the participants thereof and the person responsible thereof cannot be identified, all those who appear to have used violence upon the person of the offended party shall suffer the penalty next lower in degree than that provided for the physical injuries so inflicted. When the physical injuries inflicted are of a less serious nature and the person responsible therefore cannot be identified, all those who appear to have used any violence upon the person of the offended party shall be punished by arresto mayor from 5 to 15 days. Article 253. Giving assistance to suicide. Any person who shall assist another to commit suicide shall suffer the penalty of prisión mayor. If such person leads his assistance to another to the extent of doing the killing himself, he shall suffer the penalty of reclusion temporal. However, if the suicide is not consummated, the penalty of arresto mayor in its medium and maximum periods shall be imposed. Article 254. Discharge of firearms. Any person who shall shoot at another with any firearm shall suffer the penalty of prisión correccional in its minimum and medium periods, unless the facts of the case are such that the act can be held to constitute frustrated or attempted parricide, murder, homicide, or any other crime for which a higher penalty is prescribed by any of the articles of this code. Section 2. Infanticide and abortion. Article 255. Infanticide. The penalty provided for parricide in Article 246 and for murder in Article 248 shall be imposed upon any person who shall kill any child less than 3 days of age. If the crime penalized in this article be committed by the mother of the child for the purpose of concealing her dishonor, she shall suffer the penalty of prisión correccional in its medium and maximum periods. And if said crime be committed for the same purpose by the maternal grandparents or either of them, the penalty shall be prisión mayor. Article 256. Intentional abortion. Any person who shall intentionally cause an abortion shall suffer 1. The penalty of reclusion temporal, if he shall use any violence upon the person of the pregnant woman. 2. The penalty of prisión mayor if, without using violence, he shall act without the consent of the woman. 3. The penalty of prisión correccional in its medium and maximum periods, if the woman shall have consented. Article 257. Unintentional abortion. The penalty of prisión correccional in its minimum and medium period shall be imposed upon any person who shall cause an abortion by violence, but unintentionally. Article 258. Abortion practiced by the woman herself or by her parents. The penalty of prisión correccional in its medium and maximum periods shall be imposed upon a woman who shall practice abortion upon herself or shall consent that any other person should do so. Any woman who shall commit this offense to conceal her dishonor shall suffer the penalty of prisión correccional in its minimum and medium periods. If this crime be committed by the parents of the pregnant woman or either of them, and they act with the consent of said woman for the purpose of concealing her dishonor, the offenders shall suffer the penalty of prisión correccional in its medium and maximum periods. Article 259. Abortion practiced by a physician or midwife in dispensing of abortives. The penalties provided in Article 256 shall be imposed in its maximum period, respectively, upon any physician or midwife who, taking advantage of their scientific knowledge or skill, shall cause an abortion or assist in causing the same. Any pharmacist who, without the proper prescription from a physician, shall dispense any abortive shall suffer arresto mayor and a fine not exceeding 1,000 pesos. Section 3. Duel. Article 260. Responsibility of participants in a duel. The penalty of reclusion temporal shall be imposed upon any person who shall kill his adversary in a duel. If he shall inflict upon the latter physical injuries only, he shall suffer the penalty provided therefor, according to their nature. In any other case, the combatant shall suffer the penalty of arresto mayor, although no physical injuries have been inflicted. The second shall in all events be punished as accomplices. Article 261. Challenging to a duel. The penalty of prisión correccional in its minimum period shall be imposed upon any person who shall challenge another, or incite another to give or accept a challenge to a duel, or shall scoff at or decry another publicly for having refused to accept a challenge to fight a duel. Chapter 2. Physical Injuries. Article 262. Mutilation. The penalty of reclusion temporal to reclusion perpetua shall be imposed upon any person who shall intentionally mutilate another by depriving him, either totally or partially, or some essential organ of reproduction. Any other intentional mutilation shall be punished by prisión mayor in its medium and maximum periods. Article 263. Serious physical injuries. Any person who shall wound, beat, or assault another, shall be guilty of the crime of serious physical injuries and shall suffer 1. The penalty of prisión mayor, if in consequence of the physical injuries inflicted, the injured person shall become insane, imbecile, impotent, or blind. 2. The penalty of prisión correccional in its medium and maximum periods, if in consequence of the physical injuries inflicted, the person injured shall have lost the use of speech or the power to hear or to smell, or shall have lost an eye, a hand, a foot, an arm, or a leg, or shall have lost the use of any such member, or shall have become incapacitated for the work in which he was therefore habitually engaged. 3. The penalty of prisión correccional in its minimum and medium periods, if in consequence of the physical injuries inflicted, the person injured shall have become deformed, or shall have lost any other part of his body, or shall have lost the use thereof, or shall have been ill or incapacitated for the performance of the work in which he is habitually engaged for a period of more than 90 days. 4. The penalty of arresto mayor in its maximum period to prisión correccional in its minimum period, if the physical injuries inflicted shall have caused the illness or incapacity for labor of the injured person for more than 30 days. If the offense shall have been committed against any of the persons enumerated in Article 246, or with attendance of any of the circumstances mentioned in Article 248, the case covered by subdivision number 1 of this article shall be punished by reclusion temporal in its medium and maximum periods, the case covered by subdivision number 2 by prisión correccional in its maximum period to prisión mayor in its minimum period, the case covered by subdivision number 3 by prisión correccional in its medium and maximum periods, and the case covered by subdivision number 4 by prisión correccional in its minimum and medium periods. The provisions of the preceding paragraph shall not be applicable to a parent who shall inflict physical injuries upon his child by excessive chastisement. Article 264. Administering injurious substances or beverages. The penalties established by the next preceding article shall be applicable in the respective case to any person who, without intent to kill, shall inflict upon another any serious, physical injury, by knowingly administering to him any injurious substance or beverages or by taking advantage of his weakness of mind or credulity. Article 265. Less serious physical injuries. Any person who shall inflict upon another physical injuries not described in the preceding articles, but which shall incapacitate the offended party for labor for 10 days or more, or shall require medical assistance for the same period, shall be guilty of less serious physical injuries and shall suffer the penalty of arresto mayor. Whenever less serious physical injuries shall have been inflicted with the manifest intent to kill or offend the injured person, or under circumstances adding ignominy to the offense in addition to the penalty of arresto mayor, a fine not exceeding 500 pesos shall be imposed. Any less serious physical injuries inflicted upon the offender's parents, ascendants, guardians, curators, teachers, or persons of rank, or persons in authority, shall be punished by prisión correccional in its minimum and medium periods, provided that, in the case of persons in authority, the deed does not constitute the crime of assault upon such person. Article 266. Slight physical injuries and maltreatment. The crime of slight physical injuries shall be punished. 1. By arresto menor when the offender has inflicted physical injuries which shall incapacitate the offended party for labor from 1 to 9 days, or shall require medical attendance during the same period. 2. By arresto menor or a fine not exceeding 20 pesos and censure when the offender has caused physical injuries which do not prevent the offended party from engaging in his habitual work nor require medical assistance. 3. By arresto menor in its minimum period or a fine not exceeding 50 pesos when the offender shall ill-treat another by deed without causing any injury. Title 9. Crimes against personal liberty and security. Chapter 1. Crimes against liberty. Section 1. Illegal detention. Article 267. Kidnapping and serious illegal detention. Any private individual who shall kidnap or detain another, or in any other manner deprive him of his liberty, shall suffer the penalty of reclusion perpetua to death. 1. If the kidnapping or detention shall have lasted more than 5 days. 2. If it shall have been committed simulating public authority. 3. If any serious physical injury shall have been inflicted upon the person kidnapped or detained, or if threats to kill him shall have been made. 4. If the person kidnapped or detained shall be a minor, female or a public officer. The penalty shall be death where the kidnapping or detention was committed for the purpose of extorting ransom from the victim or any other person, even if none of the circumstances above mentioned were present in the commission of the offense. Article 268. Slight illegal detention. The penalty of reclusion temporal shall be imposed upon any private individual who shall commit the crimes described in the next preceding article without the attendance of any of circumstances enumerated therein. The same penalty shall be incurred by anyone who shall furnish the place for the perpetration of the crime. If the offender shall voluntarily release the person so kidnapped or detained within 3 days from the commencement of the detention, without having attained the purpose intended, and before the institution of criminal proceedings against him, The penalty shall be prisión mayor in its minimum and medium periods and a fine not exceeding 700 pesos. Article 269. Unlawful arrest. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any person who, in any case other than those authorized by law, or without reasonable ground therefore, shall arrest or detain another for the purpose of delivering him to the proper authorities. Section 2. Kidnapping of minors. Article 270. Kidnapping and failure to return a minor. The penalty of reclusion perpetua shall be imposed upon any person who, being entrusted with the custody of a minor person, shall deliberately fail to restore the latter to his parents or guardians. Article 271. Inducing a minor to abandon his home. The penalty of prisión correccional and a fine not exceeding 700 pesos shall be imposed upon anyone who shall induce a minor to abandon the home of his parent or guardians or the persons entrusted with his custody. If the person committing any of the crimes covered by the two preceding articles shall be the father or the mother of the minor, the penalty shall be arresto mayor or a fine not exceeding 300 pesos, or both. Section 3. Slavery and servitude. Article 272. Slavery. The penalty of prisión mayor and a fine of not exceeding 10,000 pesos shall be imposed upon anyone who shall purchase, sell, kidnap or detain a human being for the purpose of enslaving him. If the crime be committed for the purpose of assigning the offended party to some immoral traffic, the penalty shall be imposed in its maximum period. Article 273. Exploitation of child labor. The penalty of prisión correccional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon anyone who, under the pretext of reimbursing himself of a debt incurred by an ascendant, guardian or person entrusted with the custody of a minor, shall, against the latter's will, retain him in his service. Article 274. Services rendered under compulsion and payment of debt. The penalty of arresto mayor in its maximum period to prisión correccional in its minimum period shall be imposed upon any person who, in order to require or enforce the payment of a debt, shall compel the debtor to work for him, against his will, as household servant or farm laborer. Chapter 2. Crimes against security. Section 1. Abandonment of helpless persons and exploitation of minors. Article 275. Abandonment of person in danger and abandonment of one's own victim. The penalty of arresto mayor shall be imposed upon 1. Anyone who shall fail to render assistance to any person whom he shall find in an uninhabited place wounded or in danger of dying, when he can render such assistance without detriment to himself, unless such omission shall constitute a more serious offense. 2. Anyone who shall fail to help or render assistance to another whom he has accidentally wounded or injured. 3. Anyone who, having found an abandoned child under 7 years of age, shall fail to deliver said child to the authorities or to his family, or shall fail to take him to a safe place. Article 276. Abandoning a minor. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon anyone who shall abandon a child under 7 years of age, the custody of which is incumbent upon him. When the death of the minor shall result from such abandonment, the culprit shall be punished by prisión correccional in its medium and maximum periods, but if the life of the minor shall have been in danger only, the penalty shall be prisión correccional in its minimum and medium periods. The provisions contained in the two preceding paragraphs shall not prevent the imposition of the penalty provided for the act committed, when the same shall constitute a more serious offense. Article 277. Abandonment of minor by person entrusted with his custody in difference of parents. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon anyone who, having charge of the rearing or education of a minor, shall deliver said minor to a public institution or other persons, without the consent of the one who entrusted such child to his care or in the absence of the latter, without the consent of the proper authorities. The same penalty shall be imposed upon the parents who shall neglect their children by not giving them the education which their station in life require and financial conditions permit. Article 278. Exploitation of minors. The penalty of prisión correccional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon 1. Any person who shall cause any boy or girl under 16 years of age to perform any dangerous feat of balancing, physical strength, or contortion. 2. Any person who, being an acrobat, gymnast, rope walker, diver, wild animal tamer or circus manager or engaged in a similar calling, shall employ in exhibitions of these kinds children under 16 years of age who are not his children or descendants. 3. Any person engaged in any of the callings enumerated in the next paragraph preceding who shall employ any descendant of his under 12 years of age in such dangerous exhibitions. 4. Any ascendant, guardian, teacher or person entrusted in any capacity with the care of a child under 16 years of age, who shall deliver such child gratuitously to any person following any of the callings enumerated in paragraph 2 hereof, or to any habitual vagrant or beggar. If the delivery shall have been made in consideration of any price, compensation, or promise, the penalty shall in every case be imposed in its maximum period. In either case, the guardian or curator convicted shall also be removed from office as guardian or curator, and in the case of the parents of the child, they may be deprived, temporarily or perpetually, in the discretion of the court, of their parental authority. 5. Any person who shall induce any child under 16 years of age to abandon the home of its ascendants, guardians, curators, or teachers to follow any person engaged in any of the callings mentioned in paragraph 2 hereof, or to accompany any habitual vagrant or beggar. Article 279. Additional penalties for other offenses. The imposition of the penalties prescribed in the preceding articles shall not prevent the imposition upon the same person of the penalty provided for any other felonies defined and punished by this code. Section 2. Trespass to dwelling. Article 280. Qualified trespass to dwelling. Any private person who shall enter the dwelling of another against the latter's will shall be punished by arresto mayor and a fine not exceeding 1,000 pesos. If the offense be committed by means of violence or intimidation, the penalty shall be prisión correccional in its medium and maximum periods and a fine not exceeding 1,000 pesos. The provisions of this article shall not be applicable to any person who shall enter another's dwelling for the purpose of preventing some serious harm to himself, the occupants of the dwelling, or a third person, nor shall it be applicable to any person who shall enter a dwelling for the purpose of rendering some service to humanity or justice, nor to anyone who shall enter cafes, taverns, inn and other public houses, while the same are open. Article 281. Other forms of trespass. The penalty of arresto menor or a fine not exceeding 200 pesos, or both, shall be imposed upon any person who shall enter the closed premises or the fenced estate of another, while either or them are uninhabited, if the prohibition to enter be manifest and the trespasser has not secured the permission of the owner or the caretaker thereof. Section 3. Threats and coercion. Article 282. Grave threats. Any person who shall threaten another with the infliction upon the person, honor or property of the latter or of his family of any wrong amounting to a crime, shall suffer 1. The penalty next lower in degree than that prescribed by law for the crime be threatened to commit, if the offender shall have made the threat demanding money or imposing any other condition, even though not unlawful, and said offender shall have attained his purpose. If the offender shall not have attained his purpose, the penalty lower by 2 degrees shall be imposed. If the threat be made in writing or through a middleman, the penalty shall be imposed in its maximum period. 2. The penalty of arresto mayor and a fine not exceeding 500 pesos, if the threat shall not have been made subject to a condition. Article 283. Light threats. Any threat to commit a wrong not constituting a crime, made in the manner expressed in subdivision 1 of the next preceding article, shall be punished by arresto mayor. Article 284. Bond for good behavior. In all cases falling within the 2 next preceding articles, the person making the threats may also be required to give bail not to molest the person threatened, or if he shall fail to give such bail, he shall be sentenced to destierro. Article 285. Other light threats. The penalty of arresto menor in its minimum period or a fine not exceeding 200 pesos shall be imposed upon 1. Any person who, without being included in the provisions of the next preceding article, shall threaten another with a weapon or draw such weapon in a quarrel, unless it be in lawful self-defense. 2. Any person who, in the heat of anger, shall orally threaten another with some harm not constituting a crime, and who by subsequent acts show that he did not persist in the idea involved in his threat, provided that the circumstances of the offense shall not bring it within the provisions of Article 282 of this code. 3. Any person who shall orally threaten to do another any harm not constituting a felony. Article 286. Grave coercions. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any person who, without authority of law, shall, by means of violence, prevent another from doing something not prohibited by law, or compel him to do something against his will, whether it be right or wrong. If the coercion be committed for the purpose of compelling another to perform any religious act or to prevent him from so doing, the penalty next higher in degree shall be imposed. Article 287. Light coercions. Any person who, by means of violence, shall seize anything belonging to his debtor for the purpose of applying the same to the payment of the debt, shall suffer the penalty of arresto mayor in its minimum period and a fine equivalent to the value of the thing, but in no case less than 75 pesos. Any other coercions or unjust vexations shall be punished by arresto menor or a fine ranging from 5 pesos to 200 pesos, or both. Article 288. Other similar coercions. Compulsory purchase of merchandise and payment of wages by means of tokens. The penalty of arresto mayor or a fine ranging from 200 to 500 pesos, or both, shall be imposed upon any person, agent or officer, of any association or corporation who shall force or compel, directly or indirectly, or shall knowingly permit any laborer or employee employed by him or by such firm or corporation to be forced or compelled, to purchase merchandise or commodities of any kind. The same penalties shall be imposed upon any person who shall pay the wages due a laborer or employee employed by him by means of tokens or objects other than the legal tender currency of the laborer or employee. Article 289. Formation, maintenance and prohibition of combination of capital or labor through violence or threats. The penalty of arresto mayor and a fine not exceeding 300 pesos shall be imposed upon any person who, for the purpose of organizing, maintaining or preventing coalitions or capital or labor, strike of laborers or lockout of employees, shall employ violence or threats in such a degree as to compel or force the laborers or employers in the free and legal exercise of their industry or work, if the act shall not constitute a more serious offense in accordance with the provisions of this code. Chapter 3. Discovery and Revelation of Secrets. Article 290. Discovering secrets through seizure of correspondence. The penalty of prisión correccional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon any private individual who, in order to discover the secrets of another, shall seize his papers or letters and reveal the contents thereof. If the offender shall not reveal such secrets, the penalty shall be arresto mayor and a fine not exceeding 500 pesos. The provision shall not be applicable to parents, guardians, or persons entrusted with the custody of minors with respect to the papers or letters of the children or minors placed under their care or study, nor to spouses with respect to the papers or letters of either of them. Article 291. Revealing secrets with abuse of office. The penalty of arresto mayor and a fine not exceeding 500 pesos shall be imposed upon any manager, employee, or servant who, in such capacity, shall learn the secrets of his principal or master and shall reveal such secrets. Article 292. Revelation of industrial secrets. The penalty of prisión correccional in its minimum and medium periods and a fine not exceeding 500 pesos shall be imposed upon the person in charge, employee or workman of any manufacturing or industrial establishment who, to the prejudice of the owner thereof, shall reveal the secrets of the industry of the latter. Title 10. Crimes against property. Chapter 1. Robbery in general. Article 293. Who are guilty of robbery, Any person who, with intent to gain, shall take any personal property belonging to another, by means of violence or intimidation of any person, or using force upon anything shall be guilty of robbery. Section 1. Robbery with violence or intimidation of persons. Article 294. Robbery with violence against or intimidation of persons, penalties. Any person guilty of robbery with the use of violence against or intimidation of any person shall suffer 1. The penalty of reclusion perpetua to death, when by reason or on occasion of the robbery, the crime of homicide shall have been committed. 2. The penalty of reclusion temporal in its medium period to reclusion perpetua when the robbery shall have been accompanied by rape or intentional mutilation, or if by reason or on occasion of such robbery, any of the physical injuries penalized in subdivision 1 of Article 263 shall have been inflicted, provided, however, that when the robbery accompanied with rape is committed with the use of a deadly weapon or by 2 or more persons, the penalty shall be reclusion perpetua to death, as amended by PD number 767. 3. The penalty of reclusion temporal, when by reason or on occasion of the robbery, any of the physical injuries penalized in subdivision 2 of the article mentioned in the next preceding paragraph, shall have been inflicted. 4. The penalty of prisión mayor in its maximum period to reclusion temporal in its medium period, if the violence or intimidation employed in the commission of the robbery shall have been carried to a degree clearly unnecessary for the commission of the crime, or when the course of its execution, the offender shall have inflicted upon any person not responsible for its commission any of the physical injuries covered by subdivisions 3 and 4 of said Article 23. 5. The penalty of prisión correccional in its maximum period to prisión mayor in its medium period in other cases. As amended by R. 18. Article 295. Robbery with physical injuries, committed in an uninhabited place and by a band, or with the use of firearm on a street, road or alley. If the offenses mentioned in subdivisions 3, 4, and 5 of the next preceding article shall have been committed in an uninhabited place or by a band, or by attacking a moving train, streetcar, motor vehicle or airship, or by entering the passengers' compartments in a train or, in any manner, taking the passengers thereof by surprise in the respective conveyances, or on a street, road, highway, or alley, and the intimidation is made with the use of a firearm, the offender shall be punished by the maximum period of the proper penalties. In the same cases, the penalty next higher in degree shall be imposed upon the leader of the band. Article 296. Definition of a band and penalty incurred by the members thereof. When more than 3 armed malefactors take part in the commission of a robbery, it shall be deemed to have been committed by a band. When any of the arms used in the commission of the offense be an unlicensed firearm, the penalty to be imposed upon all the malefactors shall be the maximum of the corresponding penalty provided by law, without prejudice of the criminal liability for illegal possession of such unlicensed firearms. Any member of a band who is present at the commission of a robbery by the band shall be punished as principal of any of the assaults committed by the band, unless it be shown that he attempted to prevent the same. Article 297. Attempted and frustrated robbery committed under certain circumstances. When by reason or on occasion of an attempted or frustrated robbery a homicide is committed, the person guilty of such offenses shall be punished by reclusion temporal in its maximum period to reclusion perpetua, unless the homicide committed shall deserve a higher penalty under the provisions of this code. Article 298. Execution of deeds by means of violence or intimidation. Any person who, with intent to defraud another, by means of violence or intimidation, shall compel him to sign, execute or deliver any public instrument or documents, shall be held guilty of robbery and punished by the penalties respectively prescribed in this chapter. Section 2. Robbery by the use of force upon things. Article 299. Robbery in an inhabited house or public building or edifice devoted to worship. Any armed person who shall commit robbery in an inhabited house or public building or edifice devoted to religious worship shall be punished by reclusion temporal, if the value of the property taken shall exceed 250 pesos, and if a. The malefactors shall enter the house or building in which the robbery was committed, by any of the following means. 1. Through an opening not intended for entrance or egress. 2. by breaking any wall, roof, or floor or breaking any door or window. 3. By using false keys, picklocks or similar tools. 4. By using any fictitious name or pretending the exercise of public authority. Or if dash. B. The robbery be committed under any of the following circumstances. 1. By the breaking of doors, wardrobes, chests, or any other kind of locked or sealed furniture or receptacle. 2. By taking such furniture or objects to be broken or forced open outside the place of the robbery. When the offenders do not carry arms, and the value of the property taken exceeds 250 pesos, the penalty next lower in degree shall be imposed. The same rule shall be applied when the offenders are armed, but the value of the property taken does not exceed 250 pesos. When said offenders do not carry arms and the value of the property taken does not exceed 250 pesos, they shall suffer the penalty prescribed in the two next preceding paragraphs, in its minimum period. If the robbery be committed in one of the dependencies of an inhabited house, public building, or building dedicated to religious worship, the penalties next lower in degree than those prescribed in this article shall be imposed. Article 300. Robbery in an uninhabited place and by a band. The robbery mentioned in the next preceding article, if committed in an uninhabited place and by a band, shall be punished by the maximum period of the penalty provided therefor. Article 301. What is an inhabited house, public building or building dedicated to religious worship and their dependencies? Inhabited house means any shelter, ship or vessel constituting the dwelling of one or more persons, even though the inhabitants thereof shall temporarily be absent therefrom when the robbery is committed. All interior courts, corrals, waterhouses, granaries, barns, coach houses, stables or other departments or enclosed places contiguous to the building or edifice, having an interior entrance connected therewith, and which form part of the whole, shall be deemed dependencies of an inhabited house, public building or building dedicated to religious worship. Orchards and other lands used for cultivation or production are not included in the terms of the next preceding paragraph, even if closed, contiguous to the building and having direct connection therewith. The term public building includes every building owned by the government or belonging to a private person not included used or rented by the government, although temporarily unoccupied by the same. Article 302. Robbery is an uninhabited place or in a private building. Any robbery committed in an uninhabited place or in a building other than those mentioned in the first paragraph of Article 299, if the value of the property taken exceeds 250 pesos, shall be punished by prisión correccional if any of the following circumstances is present. 1. If the entrance has been effected through any opening not intended for entrance or egress. 2. If any wall, roof, floor or outside door or window has been broken. 3. If the entrance has been effected through the use of false keys, picklocks or other similar tools. 4. If any dorm, wardrobe, chest or by sealed or closed furniture or receptacle has been broken. 5. If any closed or sealed receptacle, as mentioned in the preceding paragraph, has been removed even if the same to broken open elsewhere. When the value of the property takes does not exceed 250 pesos, the penalty next lower in degree shall be imposed. In the cases specified in Articles 294, 295, 297, 299, 300, and 302 of this code, when the property taken is male matter or large cattle, the offender shall suffer the penalties next higher in degree than those provided in said articles. Article 303. Robbery of cereals, fruits, or firewood in an uninhabited place or private building. In the cases enumerated in Articles 299 and 302, when the robbery consists in the taking of cereals, fruits, or firewood, the culprit shall suffer the penalty next lower in degree than that prescribed in said articles. Article 304. Possession of picklocks or similar tools. Any person who shall without lawful cause have in his possession picklocks or similar tools especially adopted to the commission of the crime of robbery, shall be punished by arresto mayor in its maximum period to prisión correccional in its minimum period. The same penalty shall be imposed upon any person who shall make such tools. If the offender be a locksmith, he shall suffer the penalty of prisión correccional in its medium and maximum periods. Article 305. False keys. The term false keys shall be deemed to include 1. The tools mentioned in the next preceding articles. 2. Genuine keys stolen from the owner. 3. Any keys other than those intended by the owner for use in the lock forcibly opened by the offender. Chapter 2. Brigandage. Article 306. Who are brigands? Penalty. When more than 3 armed persons form a band of robbers for the purpose of committing robbery in the highway, or kidnapping persons for the purpose of extortion or to obtain ransom or for any other purpose to be attained by means of force and violence, they shall be deemed highway robbers or brigands. Persons found guilty of this offense shall be punished by prisión mayor in its medium period to reclusion temporal in its minimum period if the act or acts committed by them are not punishable by higher penalties, in which case, they shall suffer such high penalties. If any of the arms carried by any of said persons be an unlicensed firearms, it shall be presumed that said persons are highway robbers or brigands, and in case of convictions the penalty shall be imposed in the maximum period. Article 307. Aiding and abetting a band of brigands. Any person knowingly and in any manner aiding, abetting or protecting a band of brigands as described in the next preceding article, or giving them information of the movements of the police or other peace officers of the government or of the forces of the United States Army, when the latter are acting in aid of the government, or acquiring or receiving the property taken by such brigands shall be punished by prisión correccional in its medium period to prisión mayor in its minimum period. Chapter 3. Theft. Article 308. Who are liable for theft? Theft is committed by any person who, with intent to gain but without violence against or intimidation of persons nor force upon things, shall take personal property of another without the latter's consent. Theft is likewise committed by 1. Any person who, having found lost property, shall fail to deliver the same to the local authorities or to its owner. 2. Any person who, after having maliciously damaged the property of another, shall remove or make use of the fruits or object of the damage caused by him and 3. Any person who shall enter an enclosed estate or a field where trespass is forbidden or which belongs to another and without the consent of its owner, shall hunt or fish upon the same or shall gather cereals or other forest or farm products. Article 309. Penalties. Any person guilty of theft shall be punished by 1. The penalty of prisión mayor in its minimum and medium periods, if the value of the thing stolen is more than 12,000 pesos but does not exceed 22,000 pesos, but if the value of the thing stolen exceeds the latter amount, the penalty shall be the maximum period of the one prescribed in this paragraph, and 1 year for each additional 10,000 pesos, but the total of the penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed and for the purpose of the other provisions of this code, the penalty shall be termed prisión mayor or reclusion temporal, as the case may be. 2. The penalty of prisión correccional in its medium and maximum periods, if the value of the thing stolen is more than 6,000 pesos but does not exceed 12,000 pesos. 3. The penalty of prisión correccional in its minimum and medium periods, if the value of the property stolen is more than 200 pesos but does not exceed 6,000 pesos. 4. Arresto mayor in its medium period to prisión correccional in its minimum period, if the value of the property stolen is over 50 pesos but does not exceed 200 pesos. 5. Arresto mayor to its full extent, if such value is over 5 pesos but does not exceed 50 pesos. 6. Arresto mayor in its minimum and medium periods, if such value does not exceed 5 pesos. 7. Arresto menor or a fine not exceeding 200 pesos, if the theft is committed under the circumstances enumerated in paragraph 3 of the next preceding article and the value of the thing stolen does not exceed 5 pesos. If such value exceeds said amount, the provision of any of the 5 preceding subdivisions shall be made applicable. 8. Arresto menor in its minimum period or a fine not exceeding 50 pesos, when the value of the thing stolen is not over 5 pesos, and the offender shall have acted under the impulse of hunger, poverty, or the difficulty of earning a livelihood for the support of himself or his family. Article 310. Qualified theft. The crime of theft shall be punished by the penalties next higher by 2 degrees than those respectively specified in the next preceding article, if committed by a domestic servant, or with grave abuse of confidence, or if the property stolen is motor vehicle, mail matter or large cattle, or consists of coconuts taken from the premises of the plantation or fish taken from a fish pond or fishery, or if property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident or civil disturbance. As amended by RA 120 and BP 71, May 1, 1980. Article 311. Theft of the property of the National Library and National Museum. If the property stolen be any property of the National Library or the National Museum, the penalty shall be arresto mayor or a fine ranging from 200 to 500 pesos, or both, unless a higher penalty should be provided under other provisions of this code, in which case, the offender shall be punished by such higher penalty. Chapter 4. Usurpation. Article 312. Occupation of real property or usurpation of real rights in property. Any person who, by means of violence against or intimidation of persons, shall take possession of any real property or shall usurp any real rights in property belonging to another, in addition to the penalty incurred for the acts of violence executed by him, shall be punished by a fine from 50 to 100% of the gain which he shall have obtained, but not less than 75 pesos. If the value of the gain cannot be ascertained, a fine of from 200 to 500 pesos shall be imposed. Article 313. Altering boundaries or landmarks. Any person who shall alter the boundary marks or monuments of towns, provinces, or estates, or any other marks intended to designate the boundaries of the same, shall be punished by arresto menor or a fine not exceeding 100 pesos, or both. Chapter 5. Culpable insolvency. Article 314. Fraudulent insolvency. Any person who shall abscond with his property to the prejudice of his creditors, shall suffer the penalty of prisión mayor, if he be a merchant, and the penalty of prisión correccional in its maximum period to prisión mayor in its medium period, if he be not a merchant. Chapter 6. Swindling and other deceits. Article 315. Swindling, estafa. Any person who shall defraud another by any of the means mentioned herein below shall be punished by: First, the penalty of prisión correccional in its maximum period to prisión mayor in its minimum period, if the amount of the fraud is over 12,000 pesos but does not exceed 22,000 pesos, and if such amount exceeds the latter sum, the penalty provided in this paragraph shall be imposed in its maximum period, adding 1 year for each additional 10,000 pesos, but the total penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed under the provisions of this code, the penalty shall be termed prisión mayor or reclusion temporal, as the case may be. Second, the penalty of prisión correccional in its minimum and medium periods, if the amount of the fraud is over 6,000 pesos but does not exceed 12,000 pesos. Third, the penalty of arresto mayor in its maximum period to prisión correccional in its minimum period if such amount is over 200 pesos but does not exceed 6,000 pesos, and fourth, by arresto mayor in its maximum period, if such amount does not exceed 200 pesos, provided that in the 4 cases mentioned, the fraud be committed by any of the following means. 1. With unfaithfulness or abuse of confidence, namely, A. By altering the substance, quantity, or quality or anything of value which the offender shall deliver by virtue of an obligation to do so, even though such obligation be based on an immoral or illegal consideration. B. By misappropriating or converting, to the prejudice of another, money, goods, or any other personal property received by the offender in trust or on commission, or for administration, or under any other obligation involving the duty to make delivery of or to return the same, even though such obligation be totally or partially guaranteed by a bond or by denying having received such money, goods, or other property. C. By taking undue advantage of the signature of the offended party in blank, and by writing any document above such signature in blank, to the prejudice of the offended party or of any third person. 2. by means of any of the following false pretenses or fraudulent acts executed prior to or simultaneously with the commission of the fraud. A. By using fictitious name, or falsely pretending to possess power, influence, qualifications, property, credit, agency, business or imaginary transactions, or by means of other similar deceits. B. By altering the quality, fineness or weight of anything pertaining to his art or business. C. By pretending to have bribed any government employee, without prejudice to the action for calumny which the offended party may deem proper to bring against the offender. In this case, the offender shall be punished by the maximum period of the penalty. D. By postdating a check, or issuing a check in payment of an obligation when the offender therein were not sufficient to cover the amount of the check. The failure of the drawer of the check to deposit the amount necessary to cover his check within 3 days from receipt of notice from the bank and/or the payee or holder that said check has been dishonored for lack or insufficiency of funds shall be prima facie evidence of deceit constituting false pretense or fraudulent act. As amended by R. 4885, approved June 17, 1967. E. By obtaining any food, refreshment or accommodation at a hotel, inn, restaurant, boarding house, lodging house, or apartment house and the like without paying therefor, with intent to defraud the proprietor or manager thereof, or by obtaining credit at hotel, inn, restaurant, boarding house, lodging house, or apartment house by the use of any false pretense, or by abandoning or surreptitiously removing any part of his baggage from a hotel, inn, restaurant, boarding house, lodging house or apartment house after obtaining credit, food, refreshment or accommodation therein without paying for his food, refreshment or accommodation. 3. Through any of the following fraudulent means. A. By inducing another, by means of deceit, to sign any document. B. By resorting to some fraudulent practice to ensure success in a gambling game. C. By removing, concealing or destroying, in whole or in part, any court record, office files, document or any other papers. Article 316. Other forms of swindling. The penalty of arresto mayor in its minimum and medium period in a fine of not less than the value of the damage caused and not more than 3 times such value, shall be imposed upon 1. Any person who, pretending to be owner of any real property, shall convey, sell, encumber or mortgage the same. 2. Any person who, knowing that real property is encumbered, shall dispose of the same, although such encumbrance be not recorded. 3. The owner of any personal property who shall wrongfully take it from its lawful possessor, to the prejudice of the latter or any third person. 4. Any person who, to the prejudice of another, shall execute any fictitious contract. 5. Any person who shall accept any compensation given him under the belief that it was in payment of services rendered or labor performed by him, when in fact he did not actually perform such services or labor. 6. Any person who, while being a surety in a bond given in a criminal or civil action, without express authority from the court or before the cancellation of his bond or before being relieved from the obligation contracted by him, shall sell, mortgage, or, in any other manner, encumber the real property or properties with which he guaranteed the fulfillment of such obligation. Article 317. Swindling a minor. Any person who, taking advantage of the inexperience or emotions or feelings of a minor to his detriment, shall induce him to assume any obligation or to give any release or execute a transfer of any property right in consideration of some loan of money, credit or other personal property, whether the loan clearly appears in the document or is shown in any other form, shall suffer the penalty of arresto mayor and a fine of a sum ranging from 10 to 50% of the value of the obligation contracted by the minor. Article 318. Other deceits. The penalty of arresto mayor and a fine of not less than the amount of the damage caused and not more than twice such amount shall be imposed upon any person who shall defraud or damage another by any other deceit not mentioned in the preceding articles of this chapter. Any person who, for profit or gain, shall interpret dreams, make forecasts, tell fortunes, or take advantage of the credulity of the public in any other similar manner, shall suffer the penalty of arresto mayor or a fine not exceeding 200 pesos. Chapter 7. Chattel Mortgage. Article 319. removal, sale or pledge of mortgaged property. The penalty or arresto mayor or a fine amounting to twice the value of the property shall be imposed upon 1. Any person who shall knowingly remove any personal property mortgaged under the chattel mortgage law to any province or city other than the one in which it was located at the time of the execution of the mortgage, without the written consent of the mortgagee or his executors, administrators or assigns. 2. Any mortgager who shall sell or pledge personal property already pledged, or any part thereof, under the terms of the chattel mortgage law, without the consent of the mortgagee written on the back of the mortgage and noted on the record hereof in the office of the Register of Deeds of the province where such property is located. Chapter 8. Arson and Other Crimes Involving Destructions. Article 320. Destructive arson. The penalty of reclusion temporal in its maximum period to reclusion perpetua shall be imposed upon any person who shall burn 1. Any arsenal, shipyard, storehouse or military powder or fireworks factory, ordnance, storehouse, archives or general museum of the government. 2. Any passenger train or motor vehicle in motion or vessel out of port. 3. In an inhabited place, any storehouse or factory of inflammable or explosive materials. Article 321. Other forms of arson. When the arson consists in the burning of other property and under the circumstances given hereunder, the offender shall be punishable. 1. By reclusion temporal or reclusion perpetua. A. If the offender shall set fire to any building, farmhouse, warehouse, hut, shelter, or vessel in port, knowing it to be occupied at the time by one or more persons. B. If the building burned is a public building and value of the damage caused exceeds 6,000 pesos. C. If the building burned is a public building and the purpose is to destroy evidence kept therein to be used in instituting prosecution for the punishment of violators of the law, irrespective of the amount of the damage. D. If the building burned is a public building and the purpose is to destroy evidence kept therein to be used in legislative, judicial or administrative proceedings, irrespective of the amount of the damage or provided, however, that if the evidence destroyed is to be used against the defendant for the prosecution of any crime punishable under existing laws, the penalty shall be reclusion perpetua. E. If the arson shall have been committed with the intention of collecting under an insurance policy against loss or damage by fire. 2. By reclusion temporal. A. If an inhabited house or any other building in which people are accustomed to meet is set on fire, and the culprit did not know that such house or building was occupied at the time, or if he shall set fire to a moving freight train or motor vehicle, and the value of the damage caused exceeds 6,000 pesos. B. If the value of the damage caused in paragraph B of the preceding subdivision does not exceed 6,000 pesos. C. If a farm, sugar mill, cane mill, mill central, bamboo groves or any similar plantation is set on fire and the damage caused exceeds 6,000 pesos and D. If grain fields, pasture lands, or forests, or plantings are set on fire and the damage caused exceeds 6,000 pesos. 3. By presión mayor. A. If the value of the damage caused in the case mentioned in paragraphs A, C, and D in the next preceding subdivision does not exceed 6,000 pesos. B. If a building not used as a dwelling or place of assembly, located in a populated place, is set on fire, and the damage caused exceeds 6,000 pesos. 4. By presión correccional in its maximum period to presión mayor in its medium period. A. If a building used as dwelling located in an uninhabited place is set on fire and the damage caused exceeds 1,000 pesos. B. If the value or the damage caused in the case mentioned in paragraphs C and D of subdivision 2 of this article does not exceed 200 pesos. 5. By presión correccional in its medium period to presión mayor in its minimum period, when the damage caused is over 200 pesos but does not exceed 1,000 pesos, and the property referred to in paragraph A of the preceding subdivision is set on fire, but when the value of such property does not exceed 200 pesos, the penalty next lower in degree than that prescribed in this subdivision shall be imposed. 6. The penalty of prisión correccional in its medium and maximum periods, if the damage caused in the case mentioned in paragraph B of subdivision 3 of this article does not exceed 6,000 pesos but is over 200 pesos. 7. The penalty of prisión correccional in its minimum and medium periods, if the damage caused in the case mentioned paragraph B, subdivision 3 of this article does not exceed 200 pesos. 8. The penalty of arresto mayor and a fine ranging from 50 to 100 per centum if the damage caused shall be imposed when the property burned consists of grain fields, pasture lands, forests, or plantations when the value of such property does not exceed 200 pesos. As amended by R. 5467, approved May 12, 1969. Article 322. Cases of arson not included in the preceding articles. Cases of arson not included in the next preceding articles shall be punished. 1. By arresto mayor in its medium and maximum periods, when the damage caused does not exceed 50 pesos. 2. By arresto mayor in its maximum period to prisión correccional in its minimum period, when the damage caused is over 50 pesos but does not exceed 200 pesos. 3. By prisión correccional in its minimum and medium periods, if the damage caused is over 200 pesos but does not exceed 1,000 pesos, and 4. By prisión correccional in its medium and maximum periods, if it is over 1,000 pesos. Article 323. Arson of property of small value. The arson of any uninhabited hut, storehouse, barn, shed, or any other property the value of which does not exceed 25 pesos, committed at a time or under circumstances which clearly exclude all danger of the fire spreading, shall not be punished by the penalties respectively prescribed in this chapter, but in accordance with the damage caused and under the provisions of the following chapter. Article 324. Crimes involving destruction. Any person who shall cause destruction by means of explosion, discharge of electric current, inundation, sinking or stranding of a vessel, intentional damaging of the engine of said vessel, taking up the rails from a railway track, maliciously changing railway signals for the safety of moving trains, destroying telegraph wires and telegraph posts, or those of any other system, and, in general, by using any other agency or means of destruction as effective as those above enumerated, shall be punished by reclusion temporal if the commission has endangered the safety of any person. Otherwise, the penalty of prisión mayor shall be imposed. Article 325. Burning one's own property as means to commit arson. Any person guilty of arson or causing great destruction of the property belonging to another shall suffer the penalties prescribed in this chapter, even though he shall have set fire to or destroyed his own property for the purposes of committing the crime. Article 326. Setting fire to property exclusively owned by the offender. If the property burned shall be the exclusive property of the offender, he shall be punished by arresto mayor in its maximum period to prisión correccional in its minimum period, if the arson shall have been committed for the purpose of defrauding or causing damage to another, or prejudice shall actually have been caused, or if the thing burned shall have been a building in an inhabited place. Article 326a. In cases where death resulted as a consequence of arson. If death resulted as a consequence of arson committed on any of the properties and under any of the circumstances mentioned in the preceding articles, the court shall impose the death penalty. Article 326b. Prima facie evidence of arson. Any of the following circumstances shall constitute prima facie evidence of arson. 1. If after the fire are found materials or substances soaked in gasoline, kerosene, petroleum, or other inflammables, or any mechanical, electrical, chemical, or traces or any of the foregoing. 2. That substantial amount of inflammable substance or materials were stored within the building not necessary in the course of the defendant's business, and 3. That the fire started simultaneously in more than one part of the building or locale under circumstances that cannot normally be due to accidental or unintentional causes, provided, however, that at least one of the following is present in any of the three above-mentioned circumstances. A. That the total insurance carried on the building and/or goods is more than 80% of the value of such building and/or goods at the time of the fire. B. That the defendant after the fire has presented a fraudulent claim for loss. The penalty of prisión correccional shall be imposed on one who plants the articles above mentioned in order to secure a conviction or as a means of extortion or coercion. As amended by R. 5467, approved May 12, 1969. Chapter 9, Malicious Mischief. Article 327. Who are liable for malicious mischief? Any person who shall deliberately cause the property of another any damage not falling within the terms of the next preceding chapter shall be guilty of malicious mischief. Article 328. Special cases of malicious mischief. Any person who shall cause damage to obstruct the performance of public functions or using any poisonous or corrosive substance or spreading any infection or contagion among cattle or who cause damage to the property of the National Museum or National Library or to any archive or registry, waterworks, road, promenade, or any other thing used in common by the public shall be punished. 1. By prisión correccional in its minimum and medium periods, if the value of the damage caused exceeds 1,000 pesos. 2. By arresto mayor, if such value does not exceed the above-mentioned amount but it is over 200 pesos and 3. By arresto menor, in such value does not exceed 200 pesos. Article 329. Other mischiefs. The mischiefs not included in the next preceding article shall be punished. 1. By arresto mayor in its medium and maximum periods, if the value of the damage caused exceeds 1,000 pesos. 2. By arresto mayor in its minimum and medium periods, if such value is over 200 pesos but does not exceed 1,000 pesos and 3. By arresto menor or fine of not less than the value of the damage caused and not more than 200 pesos, if the amount involved does not exceed 200 pesos or cannot be estimated. Article 330. Damage and obstruction to means of communication. The penalty of prisión correccional in its medium and maximum periods shall be imposed upon any person who shall damage any railway, telegraph or telephone lines. If the damage shall result in any derailment of cars, collision or other accident, the penalty of prisión mayor shall be imposed, without prejudice to the criminal liability of the offender for the other consequences of his criminal act. For the purpose of the provisions of the article, the electric wires, traction cables, signal system and other things pertaining to railways shall be deemed to constitute an integral part of a railway system. Article 331. Destroying or damaging statues, public monuments or paintings. Any person who shall destroy or damage statues or any other useful or ornamental public monument shall suffer the penalty of arresto mayor in its medium period to prisión correccional in its minimum period. Any person who shall destroy or damage any useful or ornamental painting of a public nature shall suffer the penalty of arresto menor or a fine not exceeding 200 pesos, or both such fine and imprisonment, in the discretion of the court. Chapter 10. Exemption from criminal liability in crimes against property. Article 332. Persons exempt from criminal liability. No criminal, but only civil liability, shall result from the commission of the crime of theft, swindling or malicious mischief committed or caused mutually by the following persons. 1. Spouses, ascendants and descendants, or relatives by affinity in the same line. 2. The widowed spouse with respect to the property which belonged to the deceased spouse before the same shall have passed into the possession of another and 3. Brothers and brothers-in-law and sisters-in-law, if living together. The exemption established by this article shall not be applicable to strangers participating in the commission of the crime.
You have reached the end of the Revised Penal Code, Volume 3. Volume 4 will continue with Book 2, Title 11, and Article 333. End notes. All information presented here, except for the foreword, have been lifted verbatim from publicly available copies of the Revised Penal Code of the Philippines. The foreword is provided as a short explainer and a quick guide to the 4-volume video book series. Any errors of commission or omission are ours alone. This video book has been prepared and presented by Review Central solely and entirely for educational and reference purposes. No copyright infringement intended. Review Central would like to thank all the people who contributed time and resources in putting together this 4-volume video book series, including those who shared and contributed materials and, more importantly, their time, free of charge. If you find this material useful, please like and generously share to others who may also benefit from it. You can support us by subscribing to our channel and sharing our review materials in your favorite social media platforms. Thank you.